Hi, this is Jack Holzknecht from Compliance Resource. I'm glad to see that all of you have survived the pandemic. I hope that all of those around you, or those that you love and care for, have survived as well. Um, Quick message for you today. I've been doing this compliance stuff for about 45 years now, and periodically we have a topic that impacts banks, but a lot of banks don't realize it for whatever reason. They think it doesn't apply to us. Right now, we have two topics like that. First one is Fair Debt Collection Practices Act, which is implemented by Regulation F. Then we also have the Payday Lending rules that are out there. And what I want to do is take just a couple of minutes to remind you of how these two diverse laws and regulations impact your institution. First of all, Fair Debt Collection Practices Act. The rule's been around since 1977. We never really had implementing regs to speak of in the past. Now we got Regulation F. The new rules are effective on November 30th of this year. So you've got, I'm recording this in September, so you got the rest of this month, October, and November to do policies, procedures, training. There's a lot of detail. Let me explain to you why this law and regulation applies to you. Okay? The law applies to a creditor directly if you're collecting debt owed to another. If you're collecting your own debt, generally you're not covered by fair debt collection. But if you have a debt owed to one of your directors, for example, and you're trying to help collect that, you're helping to collect the third-party debt, the full brunt of the Fair Debt Collection Practices Act and Regulation F would apply to you. The regulation can also apply to you directly if you are collecting your own debt, but you're using an assumed name. Again, that's not typically what you do, but I've seen it before. I've seen a situation where a collector in the bank is frustrated. Every time he calls the borrower, as soon as he identifies himself, they hang up. Oh, it's the bank calling again, and they hang up. All right? So he gets a bright idea that he's going to identify himself as being somebody else. So instead of saying, this is Ben Smith from ABC Bank, he calls up and says, this is Mike Jones from Armbreaker Collections. And maybe that catches their attention. They don't hang up, and then he can talk to them about collecting. Folks, I've seen that happen in banks before, and management was unaware it was even going on. But that makes the bank subject to all the requirements of Fair Debt Collection and Regulation F. All right? That's how it can apply to you directly. Collecting third-party debt, collecting your own debt using an assumed name. I don't think you do those, but it could. The law applies to you indirectly. As you go through Regulation F, there's lists of things that are harassive, oppressive, unfair, deceptive, abusive. And you go, oh, that sounds a lot like UDAP. It is like UDAP. Folks, back in 2013, the CFPB published a bulletin that basically said, if a financial institution is not complying with the principles of the Fair Debt Collection Practices, if we can't go after them directly, because they're not directly covered by the Fair Debt Collection Practices, we'll go after them under UDAP. So they told us that 8 years ago. Now, in the final regs that were published last year, if you've read them carefully, if you've been through the hundreds of pages of preamble that came out with them, very clearly the CFPB states that they don't intend to use UDAP for institutions that are not complying with the regulation when it doesn't apply to them directly. They don't intend to do that. But folks, they have not revoked their guidance. Our concern is, even though they didn't say they won't go after you, they said they don't intend to. But they've kept their bulletin. They've reserved the right to go after you. And again, clearly you got problems when you're not following the principles of the regulation. So all the principles in the regulation apply to your institution, even if the reg doesn't. The principles do. Otherwise, you got UDAP problems. All right, got another way for you. Seen a lot of situations where a bank has a debt, their own debt, they're collecting it, or trying to collect it, And they take it so far and they realize we're not making any further headway. We're not getting anything. Let's turn this over to collectors. You turn it over to collector, and you're going to let them take a big fee if they can collect anything and send you whatever it is they collect. Folks, when you turn over a debt to a collector, they are a collector. They're directly covered by everything in the regulation. You're also a vendor, and you got to manage your vendors. How do you manage a vendor's compliance with Fair Debt Collection Practices and Regulation F if you know nothing about the topic? So you have vendor management responsibilities, and a lot of them. There's things actions you must take regarding the consumer. And notice you got to send the consumer when you're going to turn this debt over to collector. So, I mean, direct responsibilities when you're just doing your vendor management. Folks, it's a lot of stuff. And the potential liability is huge. You got until the end of November to take care of that one. The other one I want to mention is payday lending. The biggest mistake that the regulators made with this is referring to the regulations as payday lending, because every bank I run into says, oh, we don't do payday loans. Yeah, you don't, but this applies to you. And they go, well, how can it apply to you? We don't do payday loans. Folks, when you get into the definition section, what they're talking about is small dollar short-term loans. And some of you go, well, we don't do those. Folks, everybody does some. I don't think you make a lot of them, but you don't have to make a lot. If you have one or two there, and I always refer to the old grandmother loan. And you got the grandmother, she's living on Social Security, she's a little old widow lady, and her dentures break. She doesn't have the cash yet. When she gets her next Social Security check, she can pay for it. Doesn't have it now. You make her a small loan because she can't go to church on Sunday unless her dentures are repaired. It'd be too embarrassing. And so you make her a little loan. Folks, you charge a very reasonable rate of interest. You're not going to make any money on it, but you do it. It's an accommodation to your customer. But folks, that's a small dollar short-term loan. You're covered. You're covered. You have some of those. So what do you need to do? Policies, procedures, training. Now, let me explain the systems you need to fully comply with the payday lending rules are monstrous. But in the rules, there is a series of exceptions. And in my experience, those lenders that are not systematically making small dollar short-term loans can lend under the exceptions. And then you don't have to do the big compliance system. I think that's what you want to do. You want to have policies and procedures explaining the only covered loans we make are under the exceptions. And so anytime we have one of those exceptions, we'll document it. And then you don't have to get caught up in the big, huge, challenging problems complying with this massive law. Now, there's also been a lot of problems. The law was effective in 2017. Then it looked like 2019. But things have gotten held up because there's some court cases going on down in Texas. The courts put a stay that said, CFPB, you can't make this effective yet. Those cases have now been settled. The currently agreed upon date is June 13th of next year. So fair debt collection, you have a couple of months. With the payday lending rules, you got until next June. So you have plenty of time to get it done, but you got to get busy. Policies, procedures, training. Both of these rules impact you. If somebody's told you otherwise, don't believe it. You need to get busy on complying. Now, folks, I've told you the problem. What good's a problem unless you have a solution? We offer several. We have webinars coming up very soon on both of these topics. We also have available sample policies, sample procedures, and other documents will help you complete a good compliance management system that assures compliance. All right. To give you more detail about our webinars, to give you more detail about our products, I'm going to let Brent explain the rest of this to you. Thank you for your attention and look forward to seeing you at our upcoming program.
Thank you, Jack. For information about our upcoming webinars that take place on October 18th and October 19th, as well as the products that you're able to purchase on these topics, you're going to visit our website, jackscomplianceresource.com. To go to the specific programs, there will be links in the description below. Thanks for joining us.